In a fiery Supreme Court clash, Justice Amy Coney Barrett unleashes sharp critiques on Pam Bondi, only to face a stunning counterattack that shakes the courtroom and redefines legal brilliance. The marble chambers of the Supreme Court buzzed with anticipation on a crisp October morning in 2025. The case, States United versus Federal Authority, promised to reshape the balance of power between state and federal governments. A federalism dispute that had legal scholars and political analysts on edge. At its core was a challenge to a federal regulation encroaching on state autonomy, and the courtroom was packed with reporters, clerks, and spectators eager to witness the intellectual firepower of the nation's highest court. Among the advocates stood Pam Bondi, former Florida Attorney General, representing a coalition of states. Her opponent, the federal government's Solicitor General, had just concluded a polished but predictable argument. Now it was Bondi's turn to face the 9 justices, and no one expected the fireworks that were about to erupt. Justice Amy Coney Barrett, known for her incisive questioning and textualist rigor, leaned forward in her chair as Bondi began. Barrett, appointed in 2020, had quickly earned a reputation as a formidable intellect, her questions often exposing gaps in even the most seasoned advocates' arguments. Bondi, a prosecutor-turned-politician, was no stranger to high-stakes legal battles, having served as Florida's Attorney General from 2011 to 2019. Yet, some in the room whispered that she was out of her depth, a political figure more accustomed to sound bites than the nuanced constitutional debates of the Supreme Court. Barrett, it seemed, shared this skepticism. As Bondi outlined her argument that the federal regulation violated the 10th Amendment by usurping state powers, Barrett interrupted with a razor-sharp question. "Ms. Bondi, your reliance on Prince versus United States seems to ignore its narrow scope," Barrett said, her tone cool but pointed. "How do you reconcile your expansive view of state sovereignty with the court's consistent deference to federal authority in cases like Garcia?" The question was a trap, designed to force Bondi into a corner. Prince limited federal commandeering of state officials, but Garcia upheld federal power over state labor laws. The room fell silent, all eyes on Bondi. A misstep could unravel her entire case. Bondi paused, but not out of hesitation. Her eyes met Barrett's, steady and unyielding. "Justice Barrett, Prince is not the ceiling of state sovereignty but its floor," she replied, her voice clear and commanding. Garcia addressed economic regulation, not the direct commandeering of state legislative processes, which this regulation attempts. The 10th Amendment draws a line at federal overreach that obliterates state identity. The response was crisp, weaving precedent with principle, and it caught Barrett off guard. A murmur rippled through the courtroom. Bondi wasn't just holding her ground. She was pushing back. Barrett, undeterred, pressed harder. "But where is that line, Ms. Bondi? Your argument risks creating a vague standard that invites endless litigation. Can you articulate a clear test for when federal action crosses it?" The question was a gauntlet, challenging Bondi to distill complex constitutional theory into a workable rule. Many advocates would have faltered, offering vague platitudes or dodging the question. Bondi, however, was prepared. She cited a string of cases: New York versus United States, Bond versus United States, and even McCulloch versus Maryland, to argue that federal power must respect the structural integrity of states as co-equal sovereigns. Her delivery was not just rehearsed, it was electric, each point landing with precision. The other justices began to lean in, their pens scratching furiously. Justice Kagan, typically reserved, raised an eyebrow. Even Chief Justice Roberts, known for his poker face, seemed intrigued. Barrett, however, wasn't ready to yield. "You're proposing a radical rebalancing of federalism," she said, her voice now tinged with challenge. "Do you expect this court to upend decades of precedent based on your interpretation?" The question hung in the air, a dare to Bondi to either double down or retreat. The tension was palpable, the courtroom a pressure cooker of intellect and ego. Bondi's next words would either cement her as a legal force or leave her argument in tatters. She took a breath, her gaze sweeping the bench, and began to unveil a framework that would later be known as the Bondi test. But before she could finish, Barrett interjected again, setting the stage for a confrontation that would echo far beyond the courtroom walls. Justice Barrett's interruption sliced through the courtroom like a blade, her voice sharp with skepticism. "Ms. Bondi, you're asking us to adopt a new constitutional standard, but you haven't addressed its practical implications. How does your so-called test avoid paralyzing federal authority?" The question was a direct challenge. Barrett's eyes locked on Bondi, daring her to falter. The room held its breath, the weight of the moment pressing down on every observer. Pam Bondi, mid-sentence, stood at a precipice. Her Bondi test, a framework to limit federal overreach while preserving state sovereignty, was still taking shape, and Barrett's jab threatened to derail it before it could fully emerge. Bondi didn't flinch. She adjusted her stance, her expression a mix of resolve and quiet defiance. "Justice Barrett, with respect, the practical implications are precisely why this test is necessary," she said, her tone measured but firm. "The federal regulation at issue doesn't just encroach, it obliterates the state's ability to govern their own affairs. My test sets a clear boundary. Federal action must not undermine the structural autonomy of states as co-equal sovereigns." She paused, letting the words sink in. "It's not paralysis, it's balance." The courtroom stirred, reporters scribbling furiously. Bondi was not only answering Barrett but turning the justice's critique into an opportunity to sharpen her argument. Barrett, however, was unrelenting. "Balance is a fine word, Ms. Bondi, but your test sounds like a recipe for judicial overreach. Are you suggesting this court should micromanage every federal-state dispute?" The question was laced with a subtle condescension, as if Bondi's framework was a naive overreach by an advocate out of her depth. The other justices exchanged glances, sensing the escalating duel. Justice Gorsuch, typically a federalism hawk, leaned forward, his expression unreadable. Justice Kagan's pen paused, her eyes flicking between Barrett and Bondi. Bondi's response was swift, her voice rising with controlled intensity. "No, Justice Barrett, I'm suggesting the court uphold the Constitution's design. The 10th Amendment isn't a suggestion, it's a mandate. My test provides a principled standard. Federal laws that directly commandeer state legislative processes or erode their core functions are unconstitutional. It's a line drawn from Prince, New York, and Bond." She cited each case with surgical precision, her command of precedent silencing the whispers of doubt in the room. "This isn't judicial overreach, it's judicial duty." The words landed like a gavel, and for a moment even Barrett seemed taken aback. The courtroom dynamic was shifting. Bondi's poise under fire was turning skeptics into grudging admirers. Justice Sotomayor, known for her probing questions, jumped in, testing Bondi's framework from a different angle. "Your test hinges on core functions, Ms. Bondi. How do we define those without inviting subjective rulings?" Bondi welcomed the question, pivoting seamlessly to explain that core functions include a state's ability to set its own laws and manage its internal governance, areas the federal regulation in question had trampled. Her answer was dense with legal theory yet accessible, a masterclass in advocacy that had the justices nodding. Barrett, however, wasn't done. Sensing Bondi's momentum, she shifted tactics, her tone now deceptively conversational. "Ms. Bondi, your passion for federalism is clear, but let's talk history. The framers envisioned a strong federal government. Doesn't your test risk reviving a states' rights doctrine that history has repeatedly rejected?" The question was a landmine. invoking the fraught legacy of states' rights to cast Bondi's argument as regressive. The room tensed, aware of the stakes. A wrong answer could paint Bondi as a fringe ideologue. Bondi's eyes narrowed, but her voice remained steady. Justice Barrett, the framers also feared centralized power. Madison warned in Federalist 45 that federal overreach could suffocate the states. My test doesn't revive old doctrines. It enforces the framers' balance. She began to weave in historical context, quoting Madison and Hamilton with ease, when Barrett leaned forward again, her next question poised to upend the exchange and test Bondi's limits in a way no one expected. Justice Barrett's gaze sharpened as she leaned forward, her voice cutting through Bondi's historical exposition like a scalpel. Ms. Bondi, you invoke Madison and Hamilton, but Federalist 45 also emphasizes federal supremacy. Your test seems to cherry-pick the framers' intent. How do you justify ignoring their clear preference for a robust national government? The question was a masterstroke, twisting Bondi's own citations against her. It was no longer just a legal challenge. It was personal, a test of whether Bondi could withstand Barrett's intellectual onslaught or crumble under the weight of her own argument. The courtroom froze, every ear straining for Bondi's response. Pam Bondi stood resolute, her posture unyielding despite the pressure. She took a measured breath, her eyes locking with Barrett's. Justice Barrett, I don't ignore federal supremacy. I contextualize it. Madison in Federalist 45 stressed that federal powers are few and defined, while state powers are numerous and indefinite. My test respects that division, ensuring the federal government doesn't swallow state sovereignty whole. Her voice carried a quiet intensity, each word deliberate. The framers didn't design a system where states are mere puppets of federal whim. My test enforces their vision of dual sovereignty, not a hierarchy. The response was bold, reframing Barrett's trap as an opportunity to underscore her framework's fidelity to constitutional design. The room buzzed with subdued gasps. Bondi wasn't just surviving Barrett's barrage, she was rewriting the narrative. Justice Alito, a known skeptic of federal overreach, nodded subtly, while Justice Kavanaugh scribbled notes, his brow furrowed. Even Chief Justice Roberts, usually impassive, betrayed a flicker of intrigue. But Barrett, undaunted, shifted her approach, her tone now probing deeper. Your test claims to protect dual sovereignty, Ms. Bondi, but it risks creating a patchwork of state laws that undermines national unity. How do you answer critics who say your framework invites chaos? The question was a curveball, forcing Bondi to defend her test's practicality while navigating the specter of disunity. Bondi's response was immediate, her confidence unshaken. National unity doesn't mean federal uniformity, Justice Barrett. The Constitution embraces diversity among states, allowing them to experiment as laboratories of democracy. My test prevents chaos by setting a clear constitutional boundary. Federal laws can't dictate how states govern their core functions. She cited United States v. Lopez and Gonzalez v. Reich to illustrate where the court had drawn similar lines, her command of precedent seamless. The alternative, unchecked federal power, creates a different chaos, one where states lose their identity entirely. Her words resonated, striking a chord with justices wary of centralized authority. The exchange was now a full-blown intellectual duel, each question from Barrett met with a counter from Bondi that raised the stakes. Justice Thomas, silent until now, interjected with a rare question. Ms. Bondi, your test relies heavily on judicial enforcement. Why should this court trust itself to wield that power without overstepping? The question, rooted in Thomas's skepticism of judicial activism, was a new hurdle, testing Bondi's ability to align her framework with judicial restraint. Bondi didn't hesitate. Justice Thomas, the court's role is to guard the Constitution's structure. My test isn't an invitation to overreach, but a call to enforce the 10th Amendment's clear limits. Judges don't create the line. The framers did. Her answer was a deft blend of humility and conviction, earning a rare nod from Thomas. Barrett, sensing the tide shifting, pressed one final time, her voice now tinged with a mix of respect and challenge. Ms. Bondi, your test is elegant in theory, but its application could unravel decades of settled law. Are you prepared to defend its consequences if it leads to outcomes you might not foresee? The question was a dare, probing not just Bondi's legal acumen, but her foresight and resolve. The courtroom leaned forward, aware that Bondi's next words could either solidify her triumph or expose a fatal flaw in her vision. The weight of Justice Barrett's question hung in the air, a challenge that demanded not just legal precision, but philosophical courage. Pam Bondi stood at the podium, the eyes of the Supreme Court and the nation upon her. Barrett's words, tinged with a grudging respect, were a final test, daring Bondi to confront the Pandora's box her Bondi test might unleash. The courtroom, already electric with tension, seemed to hold its collective breath, every spectator aware that this moment could define the case and Bondi's legacy. A misstep now could undo her meticulous defense, casting her as an idealist, unprepared for the real-world fallout of her bold framework. Bondi met Barrett's gaze, her expression resolute but not defiant. Justice Barrett, any constitutional standard carries risks, but the greater danger lies in inaction, she began, her voice steady and resonant. If this court allows federal power to erode state sovereignty unchecked, we risk a constitution, in name only. My test isn't a wrecking ball, it's a scalpel, preserving settled law while enforcing the 10th Amendment's limits. She paused, letting the metaphor linger. As for unforeseen outcomes, I trust this court's wisdom to apply the test with the same rigor it has always applied to constitutional boundaries. The answer was a masterstroke, acknowledging the stakes while turning the question back on the justice's own responsibility. The room stirred, a ripple of murmurs spreading among the clerks and reporters. Bondi had not only deflected Barrett's challenge but reframed it as a call to judicial duty. Justice Gorsuch, his pen still, seemed to nod almost imperceptibly, while Justice Kagan's eyes narrowed, her curiosity piqued. Barrett, however, wasn't ready to relent. A scalpel, Ms. Bondi, can still cut too deep, she countered, her tone now probing rather than combative. Your test assumes states can be trusted to wield their sovereignty responsibly. What if they use it to undermine federal objectives like civil rights protections? The question was a landmine, invoking the fraught history of states' rights to test Bondi's framework against its most controversial implications. Bondi's response was immediate, her voice carrying a quiet intensity. Justice Barrett, my test doesn't shield state abuses. It empowers states to govern within their constitutional sphere. Civil rights protections, rooted in the 14th Amendment, remain supreme. My test targets federal overreach, not federal authority to enforce fundamental rights. She cited Shelby County v. Holder and Brown v. Board to underscore the court's role in balancing federal and state power, her command of precedent unflinching. The Constitution doesn't let states hide behind sovereignty to violate rights, and my test doesn't change that. The answer was a tightrope walk, affirming her framework's limits while dispelling fears of a return to a dark past. The courtroom dynamic had shifted irrevocably. What began as Barrett's attempt to expose Bondi's weaknesses had evolved into a profound constitutional dialogue, with Bondi holding her own against one of the court's sharpest minds. Justice Sotomayor, sensing the moment, posed a follow-up. Ms. Bondi, your test requires judges to define core state functions. How do we avoid turning that into a subjective free-for-all? Bondi welcomed the question, outlining a principled approach based on historical state practices and constitutional text, her delivery both scholarly and accessible. Her poise was winning over even the skeptics, with reporters whispering about a star turn in the making. Barrett, now visibly engaged, leaned forward again, her tone shifting to one of genuine curiosity. "Ms. Bondi, let's assume your test is adopted. How would it apply to a case where federal and state interests are inextricably intertwined, like environmental regulation?" The question marked a turning point. No longer a challenge but an invitation to explore the test's nuances. Bondi began to respond, weaving a hypothetical that demonstrated her framework's flexibility, when Chief Justice Roberts interjected with a question that threatened to shift the focus and test her endurance in this relentless intellectual marathon. Chief Justice Roberts' voice cut through Pam Bondi's response, his measured tone carrying an edge of scrutiny. "Ms. Bondi, your test's flexibility is precisely what concerns me. If it bends to accommodate complex cases like environmental regulation, doesn't it risk becoming a judicial blank check?" The question was a formidable hurdle, testing Bondi's ability to defend her framework's clarity under pressure. The courtroom, already gripped by the escalating exchange between Bondi and Justice Barrett, now turned its focus to this new challenge. Bondi, mid-hypothetical, paused, her gaze shifting to Roberts. The marathon of intellect and endurance was nearing its climax, and every word mattered. Bondi steadied herself, her voice calm but resolute. "Chief Justice Roberts, flexibility doesn't mean ambiguity. My test is anchored in the Constitution's text and structure, requiring federal laws to respect state autonomy without compromising national imperatives." She pivoted to Barrett's environmental query, weaving it into her answer. "In environmental cases, where interests overlap, my test asks whether federal action directly commandeers state legislative processes. If it does, it's unconstitutional. If it sets standards while preserving state choice, it passes." Her example was precise, citing EPA versus EME Homer City, to illustrate how her framework could balance competing interests. "This isn't a blank check, it's a constitutional guardrail." The room was silent, the justices absorbing her clarity. Barrett, now fully engaged, nodded subtly, her earlier skepticism giving way to respect. "Ms. Bondi, your test structure is compelling, but its success hinges on judicial restraint. How do we ensure courts don't over-apply it?" The question was no longer adversarial but collaborative, a sign that Bondi had shifted the dynamic. Bondi seized the moment. "Justice Barrett, restraint comes from grounding the test in precedent and text, as this court has done in Lopez and Bond. Judges must apply it narrowly, focusing on clear federal overreach." Her answer was a call to judicial humility, resonating with the court's textualists and pragmatists alike. The oral argument drew to a close, but the tension lingered as the justices retired to deliberate. Weeks later, the court's decision in States United versus federal authorities stunned the legal world. In a 6-3 ruling, the majority struck down the federal regulation, adopting key elements of Bondi's framework. Justice Barrett, writing the opinion, explicitly endorsed the Bondi test, defining it as a standard to protect state sovereignty while preserving federal authority. "Ms. Bondi's advocacy," Barrett wrote, "reminds us that the Constitution's balance is not static but dynamic, requiring vigilant defense." The acknowledgement was unprecedented, cementing Bondi's triumph and marking a rare moment of judicial humility from Barrett. The decision reverberated beyond the courtroom. Legal scholars hailed the Bondi test as a landmark in federalism, predicting its influence for decades. Bondi, once underestimated as a political figure, was now celebrated as a legal titan, her performance in the Supreme Court a masterclass in advocacy. Barrett, too, earned praise for her willingness to engage Bondi as an equal, her opinion reflecting an intellectual openness that reshaped perceptions of her as a justice. The confrontation, initially a clash of wills, had evolved into a defining moment for both women, showcasing the power of ideas to bridge divides. In the aftermath, Bondi returned to Florida, where she was greeted as a hero by state leaders. At a quiet dinner with her team, she reflected on the ordeal, her voice soft but firm. "We didn't just win a case. We reminded the nation what the Constitution stands for." Barrett, meanwhile, spoke at a legal conference, acknowledging Bondi's brilliance. "Advocates like Ms. Bondi push us to be better," she said, a rare public nod to an adversary. The Bondi test began appearing in law school curricula, a testament to its enduring impact. For the legal community, the case was a lesson in intellectual humility and the unexpected brilliance that can emerge when minds meet in the crucible of the Supreme Court. The story of Barrett and Bondi became legend, a tale of confrontation transformed into constitutional triumph.